Will the House please come to order and members kindly take their seats? Just a reminder, we are on House Bill 527, an act relating to extending the sunset of 30 VSA's Chapter 248A. The question is, shall the House concur in the Senate proposal of amendment with further proposal of amendment thereto as offered by the member from Pollitt, member from Dover?
Thank you, Madam Speaker. Just a reminder, the House and Senate, I will speak for the House. The House took extensive testimony this year from many Vermonters about the process and concurred with the member from Pollitt and others that this area of legislation needs work. We proposed, and this body passed, a workshop with the PUC to come back with recommendations next year on how to propose or how to improve this process. The Senate felt that the issue needed to be addressed immediately and took that out, and instead now has required that there be a mandatory hearing, which now is not required, with the developer of the tower, which now is not required, and that the Department of Public Service must attend, which now is not required. We believe that this will definitely begin to address some of these issues, and that this is an area of policy that we will need to come back to. And so we are asking the body again to vote with the committee, which found this amendment unfavorable by a vote of 6-3, and to vote no.
The question is, shall the House concur in the Senate proposal of amendment with further proposal of amendment thereto as offered by the member from Pollitt? Are you ready for the question? Member from Ferrisburg.
Thank you, Madam Speaker. In 2021, the Environmental Health Trust won a landmark case resulting in the U.S. Federal Court of Appeals in Washington, D.C. to order the Federal Communications Commission, that's the FCC, to explain why it ignored an abundance of scientific evidence showing harm from wireless radio frequency, that's RF radiation. The court order directed the FCC to address the health effects of RF radiation on children, on the environment, and the impacts from long-term and cumulative exposures of RF radiation. The FCC has ignored this court order and instead is moving to accelerate wireless infrastructure expansion without addressing the serious health concerns that it poses. On May 18th of this year, literally just a week ago, a petition was filed with a federal court to order the FCC to comply with the 2021 court mandate and update its 30-year-old RF radiation exposure limits. As the representative from Pollitt has shared with us, towns and neighbors in Vermont are struggling with the lack of ability to participate in this Section 248A process. Now that we have this federal court order to address the health effects of RF radiation exposure, we can no longer, as a state, just rest on the previous mandate to ignore its ill effects. We all likely have telecom towers or planned telecom towers in our districts. And we have constituents that are concerned about these towers and their placements. Vermonters deserve responsibly sited telecom infrastructure that does not compromise health and safety of our families and communities. For over a decade, every 3 years, this body has kicked this can down the road. Another 3 years. We did it in 2014, 2017, 2020, 23. Now we're here again being asked in 2026 to ignore the adverse health effects of RF radiation and kick it down the road another 3 years. I say no, Madam Speaker. It's time to stop and deal with this issue. A 1-year extension to the sunset is sufficient to force us to deal with this issue next year. The Senate moved us in the right direction, but I feel like we need to address this sooner. The PUC has previously been asked to fix this exact problem in 248A process and incorporate public input, but that hasn't happened. It's not what 248A process is designed for. Even if the 248A process sunsets, which it would in 3 years or 1 year with this amendment, it just reverts back to Act 250. Now that might sound like, oh no, it reverts to Act 250, but in fact, controlling commercial development is exactly what Act 250 is for. That's what it's designed to do. Why would we subject businesses and housing developments to Act 250 but not telecom towers? Makes no sense. Telecom towers are definitely commercial development. So let's address this issue and the legitimate concerns of Vermonters by supporting this amendment. We can work to ensure both reliable cell coverage and responsible telecom tower siting. And this is possible within the next year. This is a public health and public engagement issue, and I encourage everyone to vote yes on this amendment.
Are you ready for the question? Member from Putney.
Thank you, Madam Speaker. Being in this body for 20 years, pieces of information come and go, and come around again sometimes. About 10 years ago, I was approached by a group of constituents about this issue and the oncoming threat that they saw from the increase of cell towers and anything. Some of it, they wanted us to ban public Wi-Fi. They wanted us to ban cell towers. I was told this was an extinction level event we should be prepared for, that people were going to start dropping dead. Haven't seen that yet. Madam Speaker, may I read from a report from Science Direct that was commissioned and partly funded by the World Health Organization, New Zealand Ministry of Health, Institute Superior de Sanitaire, as a WHO collaborating center for radiation and health?
You may.
I'm just going to read the conclusion. For near-field RF EMF exposure to the head from mobile phones, there was low certainty of evidence that it does not increase the risk of leukemia, non-Hodgkin's lymphoma, or thyroid cancer. For occupational RF EMF exposure, there was little evidence that it increases the risk of lymphomatopoietic system tumors or oral cavity pharynx cancer. There was not sufficient evidence to assess the effect of whole body far field RF exposure from fixed site transmitters, or the effect from any source or any other important neoplasms. This has been studied. It's been studied around the world. And while science shares that things are always evolving, and that we would do well to continue to look at how science continues to evolve, I'm not ready to support this. I've been looking into this for several years, and I haven't seen the evidence yet. And I certainly haven't seen the extinction level event that was predicted 10 years ago.
Are you ready for the question? Member from Cabot.
Thank you, Madam Speaker. I just wanted to talk about a pattern that I see generally coming from this body, and that's, a large company that is able to construct and site telecom structures is given a channel through 248A to streamline the process and make it easier for them. Whereas, when I look at things like 181 and other acts that have gone through here where we're seem to be trying to be more prescriptive and regulatory in nature toward the individual and small businesses, it makes me wonder why are we being lenient and providing streamlined processes to giant corporations while we're being more prescriptive and regulatory toward our own citizens. It's a big question mark for me, and that's why I'm going to vote yes on the amendment. I think this needs to be addressed. I think there are plenty of our constituents that see the need for this to be addressed properly. I don't think what the Senate has offered is doing it enough justice. It needs to be involving more community input, despite what one or another might think about the health effects. It's still people who live in these towns and have to live near these structures. And we need to make sure that they have plenty of input. So I think we need to come back and revisit this and do it as soon as possible. And I'm going to vote yes on the amendment.
Are you ready for the question? Member from Manchester.
Madam Speaker, I thank the members for this good discussion. I just want to remind folks about some of the issues that we discussed this morning and that we had discussed in earlier testimony when we passed out the bill before crossover. But in particular, some of the things we learned this morning were what could happen or what could be the result of regulatory uncertainty. And so with the bill that we have before us, I disagree. I do think we are taking an immediate step to improve the ability of towns and Vermonters to engage in this process with a meeting that is held and hosted by their select board, by their planning commission in their town, with DPS in attendance and with the cell tower developer in attendance to answer questions in a way and in a format that I think is going to work for folks. So we are taking immediate steps. One of the main reasons that I do not support the Pritchard amendment is that things could go in one of two ways. And I don't think either way is beneficial, and I think either way would be something that Vermonters would support. Cell tower construction could grind to a halt. Developers could simply stop and wait to see what the legislature does. And for all the Vermonters who work from home or live in communities where they don't have coverage or are really wanting to see better coverage in their communities, they're going to have to wait. Or we could see what we've been told that we often see, which is that as we approach the sunset every year, there's a rush of applications and everybody tries to get cell towers built quickly. So I don't really see either of those as a desirable outcome. It is a 18 to 24 month process for a new tower to get proposed and permitted in our state. And so I do think that coming back to take a look at this next year, if that's what folks want to do, is great. But I don't think the Pritchard amendment is the solution.
Are you ready for the question? Member from Corinth.
Thank you, Madam Speaker. I want to talk about local control. We talk about it in school structure and funding with small rural towns in rural districts like my own. We need to talk about local control when it comes to tower siting as well. In one of my towns, there was a recent discussion and public outcry with respect to a prospective siting of a tower. And mysteriously, it went away not too long before the beginning of this session. And I was just on the phone with one of my constituents this morning to find out that that tower siting is resurfaced. And I think with respect to one of the members bringing up the coincidences, I think it's no coincidence that with the language and the dates in the bill as it stands are, they're not really coincidence. I think it would give enough time for a tower company to be able to get a tower in a location that is not very popular in my rural district where health concerns can be ignored. And it was one of the main concerns in my district. We have small rural towns and rural districts that have limited resources and limited staff and limited control the way the bill is written. Bringing this to a sunset and bringing it back next session gives my rural district and many others the control and the seat at the table that they desire. I support this amendment.
The question is, shall the House concur in the Senate proposal of amendment with further proposal of amendment thereto as offered by the member from Pollitt, member from Derby?
Thank you, Madam Speaker. We have a rule here, no props, so I won't hold up my prop. In my line of work, being connected is a matter of business, it's a matter of functionality, and it's a matter of safety. Our school kids went through the pandemic. They needed to be connected. Vermont does not have hardwire run everywhere, fiber optics run everywhere, so people can be connected. But through good Wi-Fi, good cell service, they can be connected. The member from Stowe has talked about being in areas where he's working and he tells his wonderful significant other, you know, if you don't hear from me by 5 o'clock, send a rescue team. These are risks that we take living in rural Vermont, but connectivity makes our jobs easier and our lives easier. And I've seen cell towers get, you know, people get mad because that son of a gun's gonna make money off it. Well, when you own land, you hope to make a little money off it. So anyways, I'm pro cell towers. And for this reason, I'll be voting against this amendment. And then hope that if the Senate proposal sticks in a biennium, we can figure it out. Thank you.
Member from Dover. Are you ready for the question? Member from St. Johnsbury.
Thank you, Madam Speaker. I just wanted to highlight the significance of the Senate's amendment to require the Public Service Department to be present at the municipal hearings, municipally run hearings, at which the applicant for cell tires is also required to be there. And those hearings are required to be held. Those are public hearings, and those are a chance for the public at the municipal level to have a say in a proposed cell tire application. The significance of this is that the process is run, 248A process is run by the Public Utility Commission, which is, as members probably are aware, is a quasi-judicial body, much like a court, with a very rigid procedure and standards of evidence and all that sort of thing that really requires an attorney to navigate, and an attorney who's familiar with the process. So the point of having the Public Service Department conduct an informal hearing, a less formal hearing, at the municipal level, is to give the public access to the process without having to go through without being forced to go through the Public Utility Commission process, that being the only avenue. Of course, the public can still participate in the Public Utility Commission process, but it is, as I say, much more formal. So that's really an important change, and I think makes the whole siting process much more public friendly.
Are you ready for the question? If so, will the clerk please call the roll?
Arsenault of Williston.
2 minutes. Will the House please come to order? Will the House please come to order and members kindly take their seats? I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of electronic device. Please refrain from the passing of notes and conversation during a roll call. And when the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your votes. The question is, shall the House concur in the Senate proposal of amendment with further proposal of amendment thereto as offered by the member from Paulet? Will the clerk please continue to call the roll?
Austin of Colchester. Bailey of Hyde Park. Bartholomew of Heartland. Bartley of Fairfax. Rebecca Winooski. Byrong of Virgins. Bishop of Colchester. Black of Essex. Bloomley of Burlington. Boslin of Westminster. Bosch of Clarendon. Putney City. Boyden of Cambridge. Brady of Williston. Brannigan of Georgia. Brigham of St. Albans Town. Brown of Richmond. Burdett of West Rutland. Burke of Brattleboro. Burkhardt of South Burlington. Burrows of West Windsor. Burdick Cabot. Campbell St. Johnsbury. Canfield of Fairhaven. Kears Duncan of Whitingham. Casey Montpelier. Casey Hubbardton. Chapin of East Montpelier. Charlton of Chester. Christie of Hartford. Chena of Burlington. Coffin of Cavendish. Cole of Hartford. Conlon of Cornwall. Cooper of Pownell. Corcoran of Bennington. Critchlow of Colchester. Tamar of Venusburg. Dickinson of St. Albans Town. Dobrovich of Williamstown. Dodge of Essex. Dolan of Essex Junction. Dogan of St. Johnsbury. Donahue of Northfield. Duke of Burlington. Derby of Shaftesbury. Eastus of Guilford. Emmons of Springfield. Feltus of Linden. Galfetti of Berrytown. Garifano of Essex. Coleman of Rockingham. Goodnow of Butterboro. Ghostland of Northfield. Ghostland of Northfield. Granting of Jericho. Greer Bennington. Gregoire of Fairfield. Hango of Berkshire. Harpel of Glover. Harvey of Castleton. Hedrick of Burlington. Higley of Lowell. Holcomb of Norwich. Hooper of Randolph. Houghton of Essex Junction. Howard of Rutland City. Howland of Rutland Town. Hoyt of Hartford. Hunter of Manchester. James of Manchester. Kosenska of Burke. Keyser of Rutland City. Kimball of Woodstock. Klepner of Burlington. Kornheiser of Brattleboro. Krasnow, South Burlington. Labor of Morgan. Lally of Shelburne. Malone of South Burlington. Lamont of Morristown. LaRoche of Franklin. Lipsky of Stowe. Logan of Burlington. Long of Newfane. Long of Milton. Leaders of Lincoln. Luno of St. Albans City. McGuire of Rutland City. Malay of Pittsford. Marcotte of Coventry. Maslin of Thetford. McCain of Montpelier. McCoy of Pulteney. McGill of Bridport. Mickless of Milton. Mahaly of Calais. Minier of South Burlington. Morganella Milton. Morgan Emma Milton. Morse of Springfield. Morse of Bennington. Morrow of Weston. Rowicki of Putney. Nelson of Derby. Nielsen of Brandon. Niagara of Bennington. North of Ferrisburg. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie Burlington. Oliver of Sheldon. Olson of Starksboro. Page of Newport City. Parsons of Newberry. Pezzo of Colchester. Hinton of Dorset. Pouch of Heinsberg. Powers of Waterford. Priestley of Bradford. Pritchard of Pollitt. Quimby of Linden. Richardson of Burlington. Sakowitz of Randolph. Shy of Middlebury. Scully of Burlington. Sheldon of Middlebury. Sibilia of Dover. Susie of Berrytown. Southworth of Walden. Squirrel of Underhill. Steady of Milton. Stevens of Waterbury. Stone of Burlington. Sweeney of Shelburne. No. Taglavia Crint. Yes. Taylor Mendon. Tomlinson of Winooski. Torrey Moortown. Walker of Swanton. Wausau Stackberry City. Waters Evans of Charlotte. Wells of Brownington. White of Waitsfield. White Bethel. Winter of Ludlow. Wood of Waterbury. Yakavoni of Morristown. Boslin of Westminster. Brown of Richmond. Christie of Hartford. Dodge of Essex. Harpel of Glover. Harvey of Castleton. Howard of Rutland City. Rachelson of Burlington. Torrey Moortown. Waters Evans of Charlotte.
For purpose of explanation, member from Weston.
While the sentiment which inspired this amendment is just and good, changing the sunset to 1 year is not the answer. I do hope we revisit this issue next year and we continue to build in more mechanisms for everyday Vermonters to have their voices heard.
Member from Milton.
I voted no, yes. Because when I ran to be a representative, I ran for public safety. I would rather delay the process until it's positive it's safe to move forward, especially when they are close to a residence.
Member from Charlotte.
Madam Speaker, may I vote?
You may.
Waters Evans of Charlotte.
Yeah.
Madam Speaker, may I explain my vote?
Member from St. Johnsbury, you may.
Thank you. I vote no. The effect of a 1-year sunset may be to halt telecommunications development, further marginalizing rural areas and the ability to attract and retain the next generation of Vermonters. Or a 1-year sunset could accelerate cell tower development with even less public input. Either outcome is not desirable.
Members, please listen to the results of your vote. Those voting yes, 52. Those voting no, 89. The nays have it, and you have declined to propose that to further amend thereto. So now we turn to the recurring question, which is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? Member from Lowell? The member from Lowell requests that when the vote is taken, it be taken by roll. Is the member sustained? The member is sustained. When the vote is taken, it will be taken by roll. The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? Member from Dover.
Madam Speaker, reiterating that the House Energy and Digital Infrastructure took weeks of testimony on this, agrees and has heard from Vermonters that there need to be changes, and we, on a straw poll of 6-3, agreed with the Senate changes to bring in a mandatory hearing in the town with the department and the developer, and we are asking the body to vote yes.
Are you ready for the question? If so, will the clerk please call the roll?
Arsenault, Williston.
2 minutes. Will the House please come to order? Will the House please come to order? And members kindly take their seats. I would like to remind members that we are in the middle of a roll call vote. Members and guests are prohibited from using computers, phones, or any type of electronic device. Please refrain from the passing of notes and conversation during the roll call. And when the clerk calls your name, please answer in a loud and clear voice so the clerk can accurately record your votes. The question is, shall the House concur in the Senate proposal of amendment? Will the clerk please continue to call the roll?
Austin of Colchester. Bailey of Hyde Park. Bartholomew of Heartland. Bartley of Fairfax. Rebecca of Winooski. Byron of Virgins. Bishop of Colchester. Black of Essex. Bloomley of Burlington. Bosland of Westminster. Bosch of Clarendon. Gutenberry City. Boyne of Cambridge. Brady of Williston. Brannigan of Georgia. Brigham of St. Albans Town. Brown of Richmond. Burdett of West Rutland. Burke of Brattleboro. Yes. Burkhart of South Burlington. Yes. Burrows of West Windsor. Yes. Burdick Cabot. Campbell of St. Johnsbury. Campfield of Fairhaven. Carrie Stunken of Whitingham. Casey Montpelier. Casey Hubbardton. Chapin East Montpelier. Charles Chester. Christie of Hartford. Sheena of Burlington. Coffin of Cavendish. Cole of Hartford. Conlon of Cornwall. Cooper of Pownell. Corcoran of Bennington. Critchlow of Colchester. Tamara of Venusburg. Dickinson of St. Albans Town. Dobrovich of Williamstown. Dodge of Essex. Dolan of Essex Junction. Dolgan of St. Johnsbury. Donahue of Northfield. Duke of Burlington. Durfee of Shaftesbury. Eastus of Guilford. Emmas of Springfield. Felton of Linden. Galfetti of Berrytown. Garifano of Essex. Goldman of Rockingham. Goodnow of Brattleboro. Ghostland of Northfield. Granting of Jericho. Greer of Bennington. Gregoire of Fairfield. Hango of Berkshire. Harpel of Glover. Harvey of Castleton. Hedrick of Burlington. Higley of Lowell. Holcomb of Norwich. Hooper of Randolph. Houghton of Essex Junction. Howard of Rutland City. Howland of Rutland Town. Hoyt of Hartford. Hunter of Manchester. James of Manchester. Kosenska of Burke. Keyser of Rutland City. Kimball of Woodstock. Klepner of Burlington. Kornheiser of Brattleboro. Krasnow, South Burlington. Labor of Morgan. Lally of Shelburne. Malone of South Burlington. Lamont of Morristown. LaRush of Franklin. Lipsky of Stowe. Logan of Burlington. Long and Newfane. Long and Milton. Leaders of Lincoln. Luno of St. Albans City. McGuire of Rutland City. Malay of Pittsford. Marcotte of Coventry. Maslin of Thetford. McCann of Montpelier. McCoy of Pulteney. McCoy of McGill of Report. Mickless of Milton. Mahaly of Calais. Minier of South Burlington. Morganella Milton. Morgan Emma Milton. Morse of Springfield. Morrissey of Bennington. Morrow of Weston. Rowicki of Putney. Nelson of Derby. Nielsen of Brandon. Niagara of Bennington. North of Ferrisburg. Noyes of Wolcott. Nugent of South Burlington. O'Brien of Tunbridge. Odie Burlington. Oliver of Sheldon. Olson of Starksboro. Page of Newport City. Parsons of Newberry. Pezzo of Colchester. Pincenol of Dorset. Pouch of Heinsberg. Powers of Waterford. Priestley of Bedford. Pritchard Pollitt. Quimby of Linden. Rachelson of Burlington. Sakowitz of Randolph. Shy of Middlebury. Scully of Burlington. Sheldon of Middlebury. Sibilia of Dover. Susie of Berrytown. Southworth of Walden. Squirrel of Underhill. Steady of Milton. Stevens of Waterbury. Stone of Burlington. Sweeney of Shelburne. Taglavia of Corinth. Taylor of Mendon. Tomlinson of Winooski. Torrymore Town. Walker of Swanton. Waz of Zachary City. Waters Evans of Charlotte. Wells of Brownington. White of Waitsfield. White of Bethel. Winter of Ludlow. Wood of Waterbury. Yakavoni Morristown. Boslin of Westminster. Brown of Richmond. Campbell of St. Johnsbury. Chapin East Montpelier. Christie of Hartford. Dobrovich of Williamstown. Dodge of Essex. Harpel of Glover. Harvey of Castleton. Howard or Rutland City, Hunter, Manchester, Kimball, Woodstock, Long and Newfane, Long and Milton, McKenna, Montpelier, Morganella, Milton, Quimby of Linden, Rachelson of Burlington, Torimo Town,
Member from Manchester?
May I vote?
You may.
Hunter of Manchester,
Member from Montpelier?
Madam Speaker, may I vote?
You may.
McCann of Montpelier,
Members, please listen to the results of your vote. Those voting yes, 122. Those voting no, 14. The ayes have it, and you have concurred in the Senate proposal of amendment. Member from Poultney, on our notice calendar is the Senate proposal of amendment on House Bill 686, which is an act relating to expanding identification of certain lobbying advertisements. Can you please offer us a motion to suspend rules to take up House Bill 686 off the notice calendar for immediate consideration?
Madam Speaker, I make a motion to suspend rules in order to take up off the notice calendar for immediate consideration H686.
The member from Poultney moves that we suspend our rules to take up House Bill 686 off the notice calendar for immediate consideration. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to take up House Bill 686 for immediate consideration. House Bill 686 is an act relating to expanding identification of certain lobbying advertisements. The bill passed the Senate in concurrence with a proposal of amendment that is printed in today's calendar. Member from Cambridge.
Madam Speaker, the Senate has proposed a strike all to H686 relating to expanding identification of certain lobbying advertisements. I will briefly walk through the language which can be found on page 3814 of today's House calendar. Section 1 strikes orally or in writing within the definitions of lobbying. This adjustment captures any communication for the purpose of influencing legislative or administrative action. Section 2 amends 2 VSA 264C, identification in and report of certain lobbying advertisements. Subsection A, identification, subdivision 1, language specific to the legislative session is struck to specify that an advertisement that is intended to influence legislative action or to solicit others to do so that is made at any time shall contain language that it was paid for in the name of who made the expenditure for the advertisement. Subdivision 2C specifies what's to be included in the brief description of paid advertisement or advertising campaign totaling $1,000 or more made by the lobbying entity, including any enacted or introduced bill or any issue featured in the advertisement or advertising campaign, any specific person featured in the advertisement or advertising campaign, and whether the intent or content in the advertisement or advertising campaign offers an opinion of support, opposition, or neutrality on a bill, issue, or person. Additionally, a lobbying entity advertisement report does not need to be filed if they have already filed the necessary campaign finance reports and disclosures for the same advertisement or advertisement campaign. This is aimed at preventing duplicative reporting during election campaigns. Section 3, the effective date is on passage. The committee heard from Legislative Counsel, Office of Legislative Counsel, reporter of the bill, Senate Committee on Government Operations, Director of Elections and Campaign Finance, Secretary of State's Office, Managing Director, Meadow Hill Consulting. On a straw poll of 10-0-1, your Committee on Government Operations and Military Affairs moves to concur with the Senate and asks for your support.
The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have concurred in the Senate proposal of amendment. Member from Poultney, on our notice calendar is the Senate proposal of amendment to the House proposal of amendment on Senate Bill 326, which is an act relating to miscellaneous amendments to laws regarding to motor vehicles. Can you please offer us a motion to suspend our rules to take up Senate Bill 326 off the notice calendar for immediate consideration?
Madam Speaker, I make a motion to suspend rules in order to take up off the notice calendar for immediate consideration S326.
The member from Poultney moves that we suspend our rules to take up Senate Bill 326 off the notice calendar for immediate consideration. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to take up Senate Bill 326 for immediate consideration. Senate Bill 326 is an act relating to miscellaneous amendments to laws relating to motor vehicles. The Senate concurred in the House proposal of amendment with a further proposal of amendment thereto that is printed in today's calendar. Member from Swanton.
Good afternoon, Madam Speaker. Your House Transportation Committee heard and took testimony on the Senate proposal amendment to the House proposal amendment of S326, the miscellaneous motor vehicles bill. Or, I'm sorry, miscellaneous amendments to laws pertaining to motor vehicles. There were two largely technical areas related, one to hands-free, related to hands-free operation of cell phones, related to commercial drivers, and there was another one related to mufflers related to motorcycles and the motorcycle vehicle annual inspection. And we heard testimony from the Leg Council and the Deputy Commissioner, Department of Motor Vehicles. And on a straw poll of 9-1-1, your House Transportation Committee concurs with the Senate proposal amendment to the House proposal amendment on S326.
The question is, shall the House concur in the Senate proposal of amendment to the House proposal of amendment? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have concurred in the Senate proposal of amendment. Member from Poultney, can you please offer us a motion to suspend our rules to message our action on Senate Bill 326 to the Senate forthwith?
Madam Speaker, I make a motion to suspend rules in order to message our action to the Senate on S326 forthwith.
The member from Poultney moves that we suspend our rules to message our action on Senate Bill 326 to the Senate forthwith. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to message our action on Senate Bill 326 to the Senate forthwith. Member from Poultney, on our notice calendar is the Committee of Conference report on House Bill 642, which is an act relating to youthful offender proceedings. Can you please offer us a motion to suspend rules to take up House Bill 642 off the notice calendar for immediate consideration?
Madam Speaker, I make a motion to suspend rules in order to take up off the notice calendar for immediate consideration H642.
The member from Poultney moves that we suspend our rules to take up House Bill 642 off the notice calendar for immediate consideration. Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and you have suspended rules to take up House Bill 642 for immediate consideration. House Bill 642 is an act relating to youthful offender proceedings. The bill was referred to a committee of conference on the disagreeing votes of the two chambers. The committee of conference has met and considered the same and recommends that the House adopt its report, which is printed in today's calendar. Member from Brattleboro.
Thank you, Madam Speaker. Before the body is the Committee of Conference report on H642, an act relating to youthful offender proceedings. This can be found in today's calendar on page 3820. As you'll recall, Madam Speaker, the reason for the Committee of Conference report conference was the difference of position between the two bodies as it related to victim impact statements and their role in youthful offender proceedings. There are 4 instances of amendment to H642 as it's come out of the Committee of Conference, and I'll go through them each briefly. The first is found on page 3820. This is a technical amendment to 33 VSA 5285A2, and it is a technical edit to correct a cross-reference. The second change can be found at the bottom of page 3821. This amends subsection E of the same section. It is also a technical edit that corrects another cross-reference. Moving on, Madam Speaker, to page 3822. This is in section 33 VSA 5288, rights of victims in youthful offender proceedings. This is the heart of the discussion in the Committee of Conference. There are 2 amendments. The first can be found to 33 VSA 5288 subdivision A2. The Committee of Conference essentially reverted back to the House language in the first sentence of this subdivision. This means a victim has the right to attend and present a victim impact statement at both hearings, the hearing to consider youthful offender status and the disposition hearing. In the last sentence, the Committee of Conference cross-referenced subsection B for clarity to streamline language, as this sentence refers to what a court shall do, which is explained in detail in that subsection. Moving on to the final subsection, Madam Speaker, that can be found at the bottom of page 3822. This is 33 VSA 5288 subsection B. The Committee of Conference again reverted back to the same House language with some clarity. This is consistent with the matching language that was amended before, and it provides that the court shall ask if the victim is present and would like to be heard at both hearings. And again, those are the hearings to consider the youthful offender status and the final disposition hearing. Madam Speaker, the vote out of the Committee of Conference was unanimous of 6-0-0, and we ask for the body's support.
The question is, shall the House adopt the report of the Committee of Conference on its part? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. The ayes appear to have it. The ayes do have it, and the report of the Committee of Conference is adopted. Now we'll turn to House Bill 606, which is an act relating to firearms procedures. The bill passed the Senate in concurrence with a proposal of amendment that is printed in today's calendar. Member from Williston.
Thank you, Madam Speaker. H606 came back to us from the Senate in a very different form than when it left. What left as an act related to miscellaneous firearms procedures is now an act related to firearms relinquishment and storage procedures. So it's a strike-all amendment, and it replaces the provisions of the House version of the bill with the recommendations of the Firearms Surrender Compliance Working Group. That group was formed statutorily in the Miscellaneous Judiciary Bill last year, Act 64. In its simplest terms, this is a firearms storage and safety bill. This bill improves the system for ensuring compliance with court-ordered firearms surrender. It does not create any new restrictions on possession or ownership of firearms. So because it's new to this body, I'll just take a couple minutes to walk through the bill very quickly. High level in Section 1, H606 consolidates firearms relinquishment procedures by moving the Extreme Risk Protection Order Relinquishment Authority from its current location in Title 13 to the existing RFA relinquishment, that's relief from abuse orders, relinquishment statute in the Department of Public Safety chapter of Title 20. When a court orders relinquishment, current law permits the firearms to be stored with a law enforcement agency or a firearms dealer. These are federally licensed firearms dealers, which you may hear me refer to as FFLs, or a third party designated by the owner. This bill, H606, preserves those three alternatives, but additionally clarifies and creates safer process for the third party storage or relinquishment option, namely by requiring the court to hold a hearing before firearms can be stored by a third party. And at that hearing, third parties must agree to undergo a firearms background check, and they must also sign an affidavit acknowledging receipt of the firearms and really making clear to the court that they understand the responsibility they're accepting. Section D adds an acknowledgement form that the defendant must sign, just acknowledging the relinquishment of firearms has occurred and documenting who will be storing them. Moving to subsection G, we have the details for the procedures for law enforcement storage. When law enforcement agencies are not able to store firearms that are relinquished, they can work with an FFL to store those firearms, and subsection G lays out the procedures for that type of storage. We can move to subsection H, which requires law enforcement agencies to make a reasonable effort to notify victims at least 24 hours before relinquished firearms are released, unless the plaintiff is present when the court issues the order. And this is a really important an important piece of the puzzle for victim safety. Subsection I describes the procedures for release and sale of relinquished firearms, including the notice that's required to the owner. This is once an order has expired or is no longer in effect, both law enforcement or an FFL is permitted to sell the firearms, but only after providing the required notice if those firearms are not picked up within 90 days of the end of the court order. Subsection J concerns immunity from civil and criminal liability. So current law provides such immunity to law enforcement agencies if there's any damage to firearms that are being stored. This bill extends that immunity to the FFLs, provided that the FFLs are following the processes laid out in the bill. This is an important piece as well because we want to make it easier for federally licensed firearms dealers to participate in this effort to store the firearms. So we want to ensure that FFLs have the same immunity as law enforcement. Subsection K describes the Department of Public Safety's role in establishing and implementing guidelines and standards for this relinquishment process. This bill adds a requirement that the Department of Public Safety adopt a policy that encourages FFLs to participate in providing storage. And in Section 2, we have a requirement for the Department of Public Safety to direct the Law Enforcement Advisory Board to create a statewide model law enforcement policy addressing firearms access by persons who are prohibited from possessing firearms pursuant to relief from abuse orders, extreme risk protection orders, or other legal prohibitions. And state and local law enforcement agencies will have until June 30th, 2027 to adopt that model policy. And if they don't, they are deemed to have adopted it. If they don't adopt their own policy, they're deemed to have adopted the LEAB model policy. Section 3 of the bill, you'll see a bunch of strike through. That's because in this section, we're repealing the existing firearm storage process for extreme risk protection orders, because as I noted earlier, in this bill, we're relocating all of those provisions to the same statute as the relief from abuse relinquishment provisions. Just cleaning that up, making it easier for folks to find. Lastly, the title of the bill is changed, as I said, to an act relating to firearms relinquishment and storage procedures. And Section 4 of the bill provides that it takes effect on July 1, 2026. I just want to say just a couple notes about why this matters, why this is important. As I mentioned, there are a couple of cases in which a court may order that firearms be relinquished for safety reasons. And currently, we have the law that allows such an order, but we don't have a process or a framework or structure to support that law. So what 606 does now is it really builds that framework, and then directs the Law Enforcement Advisory Board to build the policy to implement and support the framework. I will also mention that the working group that provided these recommendations was appropriately diverse and included members of, from the law enforcement community, folks who work with survivors and victims of domestic and sexual violence. We also had one FFL, federally licensed firearms dealer, as a member of that working group. And then the group also consulted with a wide range of folks. So they've met 5 times over the summer and fall. They did a lot of collaborative work. And on a straw poll of 7-4, our committee voted this bill out favorably, and we ask for your support.
The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? If so, member from Montpelier.
Madam Speaker, I was proud to stand in support of H606 as a public safety bill that would have addressed prohibiting devices that turn any gun into an automatic weapon. As a public high school teacher, it terrifies me that firearm injuries are the leading cause of death for children and teens, and have been since 2020. 4,000 young people a year die in this country. 29 states have laws prohibiting these Glock switches, including our New England neighbors of Massachusetts, Rhode Island, and Connecticut. I would have liked to see Vermont be braver, be better, and become the 30th state to prohibit these devices. I think it's the least we could have done to further the safety of our youngest Vermonters. I'm disappointed in what H606 has become, but I will support what it is.
The question is, shall the House concur in the Senate proposal of amendment? Are you ready for the question? If so, all those in favor, please say aye. Aye. All those opposed, please say nay. Nay. The ayes appear to have it. The ayes do have it, and you have concurred in the Senate proposal of amendment. Will the House please stand at ease, and can I see House leadership at the podium, please? The House will stand at Will the House please come to order and members kindly take their seats? Members, there has been an amendment sent out on Senate Bill 193, and we have word from House Education about House Bill 955, the Education Transformation Bill, and I know that there is an outstanding amendment on Senate Bill 71. So we're going to take a 15-minute break to let the committees meet and come back here to see if we can take action on those following bills. So with that, the House will stand